Good morning, everyone, and thank you for joining us this morning for our autumn WFW employment webinar, where we'll be talking about a variety of topics. I'm Devan Khagram, and I'll be chairing today's session. Before we begin, there's a few housekeeping points I wanted to cover. Just to let you know, all microphones and videos have been disabled and will remain disabled throughout the webinar. The webinar will last around an hour. But there will be a recording made which will be available afterwards. Questions are encouraged. There's a Q&A tab at the bottom of your screen. Please do submit your questions in there because we have some time at the end for questions. And please do put your name next to the question so that if we don't get to your question, we can come back to you separately. So, as I said, we've got a real variety of topics today in our webinar. Anna Robinson will be covering alcohol at work, which is quite timely. I'm sure you're all getting invites to Christmas parties, etc. At the moment. Emma Bradding and Charlotte Herrington. Charlotte, who's a new associate in our team, they'll be covering legal updates from harassment and bullying, whistleblowing, and flexible working and changes to that regime. Elliott's going to give us a bit of an update on immigration, in particular the rise in visa fees. And we're going to wrap up with a really interesting topic. Sarah's going to be talking about the employment issues that arise from AI, and AI is infiltrating every area, every industry. So we're facing a lot of challenges as to how to deal with it. So we'll be getting some early insight on that from Sarah. So I'm going to hand over now to Anna, who's going to start with her presentation. Over to you, Anna.
Thank you very much, Dev. So, as Dev said, we thought it was timely to cover my topic, which is the subject of drinking at workplace events, because we're coming into Christmas party season. And there's also been an interesting employment tribunal case, which I wanted to talk to you about today, and which I'll come on to shortly. So, as we all know, I think historically at least, the UK's had a big drinking culture. It's been very common to have alcohol at workplace events. And even though the younger generations, I think, probably drink less than perhaps the older generations, I think, and I might be wrong on this, post-COVID, in an effort to incentivise people to return to the office, there has been a bit of an increase again in socials and events where alcohol is involved. But I was really interested to get a bit of feedback on that. So I've got a poll question for you. So how many of you have banned drinking at work events altogether? It's just a simple yes or no to that question. Give you a few more seconds to respond. Okay, do we have the results? Okay. Yeah, as I expected. So interestingly, 13%, which I think it, does represent an increase over the past 5-10 years, but still the majority of employers are allowing alcohol in some form. Okay. So why do we worry about it? Well, obviously there's issues around people not turning up to work if perhaps they're hungover. But really the focus today is on discrimination related issues that can arise. And I'm thinking in particular about sexual harassment. And we all know there's been a sharp focus on that in recent years. And that was the subject in issue in the case I'm about to talk about. The CMI recently conducted a survey amongst its members, and rather alarmingly, a third of the people surveyed said that they had witnessed inappropriate behaviour, particularly harassment or perhaps even physical assault at work events where alcohol was involved. So it's definitely, or certainly can be, a problem. Next slide, please. So what are the legal issues? Well, we've got to think about health and safety, of course, when we're dealing with these harassment and assault type cases. Of course, incidents can lead to resignations and constructive dismissal claims. Negligence can be an issue. But I think the big piece is discrimination. So harassment obviously is part of the discrimination protection in the Equality Act, but I'm thinking also about inclusivity. So if, for example, you have certain team events which involve alcohol, then of course certain groups of people with certain protected characteristics as defined might feel excluded from those types of events. And I'm thinking in particular about pregnant employees, or perhaps employees with a particular health issue, which means they can't drink. And of course, certain religious groups abstain from drinking. So we have to think about that D&I piece. There's also a proposed act in motion, the Worker Protection Amendments for Equality Act, which will introduce an additional duty on employers to take reasonable steps necessary to prevent harassment. And Emma's going to talk a little bit more about that shortly, so I won't say any more on that for now. So turning then to the case, which is a case concerning the building firm, Crest Nicholson. As many of you will know, they build new homes, and I think they might be countrywide. Certainly they're based in the south. And they held a work Christmas party at the Piano Works venue in London. And it was on a Thursday, and they operated a free bar, which started, and I think this was the first mistake, at 1 p.m. in the afternoon and continued into the early hours of the next day. And apart from some food, that was really it in terms of the focus of the event. You know, it was just about drinking and being in the bar. A site manager, so reasonably senior employee, or certainly at middle management level, was drinking quite heavily, and he was seen to harass and grope a female colleague, and he did so in full view of his other colleagues, one of whom confronted him. The person who confronted him was then faced with aggression. The other people who saw it did nothing. So the site manager was allowed to stay at the event. And perhaps not surprisingly, he continued to drink, and his behaviour became worse and worse as the day continued. He accompanied another female colleague back to a hotel room which had been partly funded by the employer, I might add. And shockingly, that culminated in her rape in the hotel room. Now, the question for the tribunal was whether or not, leaving aside the criminal investigation and the criminal liability of the perpetrator, the question for the tribunal was whether or not Crest Nicholson was vicariously liable for his actions, bearing in mind that this was not in the office, it was at an external venue. And on one view, you might argue that the events which took place in the hotel could not be, or certainly one way of looking at it might be that Crest Nicholson could not be held accountable for what happened in that hotel room. But the tribunal took the view that Crest Nicholson was vicariously liable for his actions. So looking then at how they came to that view, and it's a really interesting judgment for anybody looking at this topic, a very detailed, well-considered judgment with lots of practical advice for employers when faced with this type of situation. So the question, of course, is whether or not the events of that day were in the course of employment. So the factors to take account of were, was it an extension of the workplace? Was it during or outside of work hours? Were the facilities or equipment used to commit the act provided by the employer? And what was the nature of the acts? And what was the nexus between the claimant, the victim, and the person who committed the offence? So applying those questions to the factual narrative, well, first of all, it took place on a Thursday. Okay, so that was in the working week. And interestingly, even though people were not compelled to attend, if they didn't go along, they had to take annual leave. So that was relevant in deciding whether or not they were liable. Also, it took place during the working hours, and even though it continued into the early hours of the next day. It had started at 1 p.m. in the afternoon. The bar was funded by the employer. Everybody had been given expenses either towards their travel or their accommodation. And in terms of the nexus between the perpetrator and the claimant, he was more senior to her, and she had placed trust in him because of the hierarchy in the company. And so she had felt that she could trust him when he accompanied her back to the hotel. Next slide. So the tribunal took rather a dim view, as you might expect, of how the event had been organised, because, you know, I know hindsight can be a wonderful thing, but I think any of us would agree that it was reasonably foreseeable that if you ply people with drink from 1 in the afternoon, it's likely that problems will ensue. So the tribunal said, look, if you're going to insist on having this type of event, it's not enough just to be reactive and deal with events or incidents as and when they occur. You should really have a risk assessment beforehand. So allocate managers to whom employees can report misconduct. Some people should remain sober. And if anybody misbehaves, they need to be told to go home. They need to be told to refrain from drinking. And in the case in question, arguably, after the first incident, the police should have been called, but none of those things were done. It was very reactive. Some of the people who witnessed the event did nothing about it, even though they were reasonably senior. And so the tribunal was extremely critical of the employer and its inaction during the course of that day, and indeed in the planning stage. So steps to consider then, think about your messaging. And these are the takeaway points I want you to think about after today. Have some messaging for your senior leaders in terms of reminding them about the legal framework, the sexual harassment framework, because remember, not everybody might understand what constitutes sexual harassment. You know, it's not always the most heinous acts. It might be that, for example, placing your hand in the small of somebody's back or touching their shoulder might make that person feel uncomfortable, such that the definition of harassment is met. So remind people of that, have refresher training if you need to, have separate messaging for the staff at large, encouraging them to enjoy themselves, but reminding them all to behave appropriately at all times. As I said, and as encouraged by the panel in the tribunal judgment, leaders should keep their alcohol levels low. Some people need to abstain altogether. And quite obviously, don't let alcohol be the sole focus. You know, it's a very good idea to have a different activity and just to have some drinks at the end. And I think where they went wrong was that there was no activity, no focus. It was just about having a boozy day out. Limit drinks, again, an obvious point, but having a free bar for 12 hours will invariably lead to trouble. And after parties are always a bad idea. They shouldn't be sponsored or organised by the employer. Leaders should avoid attending them altogether, and wherever possible, they should be discouraged, because that tends to be where the problems happen. And then if there are incidents, then of course, consider your investigation process, take disciplinary action where necessary, and do be consistent. So if senior leaders have behaved inappropriately, they should be held accountable to the same standard, if not a higher standard than any other members of staff who have also behaved inappropriately. So they're just some takeaways to think about. Do have a look at the judgment if you have any time. There's some interesting guidance in there as well around conducting investigations, which I don't have time to talk about today, but it is a very useful aid memoir when looking at these types of issues. Okay, so that's all from me. I'm now going to hand over to Emma, who will talk about some upcoming changes, including some legislative developments, and she will talk to you a little bit more about the harassment update I mentioned earlier. Emma, over to you.
Thanks, Anna. So yes, I'm going to cover a few notable employment law updates relating to harassment and bullying in the workplace, as well as whistleblowing. And I'll start by picking up on what Anna was saying about the Worker Protection Bill, which seeks to amend the Equality Act 2010. So this is a private member's bill that was introduced to Parliament, and it would change the law on sexual harassment. It's now onto the final stage before royal assent, so it's looking likely that it will become law, and it's pretty topical considering the number of reports in the press at the moment about sexual harassment and assault in the workplace. Now, the original wording of the bill sought to protect employees from harassment by third parties, basically any harassment relating to a protected characteristic rather than sexual harassment. And the original wording also obligated employers to take all reasonable steps to prevent sexual harassment. However, the House of Lords has done away with the third-party harassment protection from the draft legislation, and it's also changed the all reasonable steps obligation to just reasonable steps. This obviously means that the current draft legislation doesn't go as far as initially intended and is less onerous on employers. However, assuming the bill is enacted into law in its current form, employers will be under a positive obligation to take reasonable steps to prevent sexual harassment. So what does this mean? At present, employees are able to bring claims of sexual harassment under the Equality Act. Employers have a defence to the claim if they can demonstrate that they took all reasonable steps to prevent the harassment by their employee. With the new proposed legislation, if an employment tribunal was to conclude that an employee had suffered from sexual harassment and the employer had not taken reasonable steps to prevent this, it could award the employee further compensation in their sexual harassment claim. And that could be up to 25% of their compensatory award. Any standalone breaches of the positive obligation to take reasonable steps to prevent sexual harassment, for example, where the employee does not win their sexual harassment claim in the employment tribunal, could only be enforced by the Equality and Human Rights Commission. If the bill becomes law, the Equality and Human Rights Commission should draft a statutory code of practice, which employers will need to familiarise themselves with. So it's certainly an important piece of legislation to keep your eye on. Now, moving on. So a new private members bill was presented to Parliament in July called the Bullying and Respect at Work Bill. And I thought it was worth speaking about this briefly. It's unclear as to whether it will be carried over to the next parliamentary session, as the second reading is timetabled after the end of the current parliamentary session, and the bill's so early on in its legislative journey. However, it's worth a mention because even if it fails, as is often the case with private members' bills, it may at least influence future legislation. As you may be aware, currently there's no specific claim an employee can bring in an employment tribunal simply for being bullied at work. Employees who resign may bring a constructive dismissal claim. However, constructive dismissal is a difficult claim for an employee to successfully make. Alternatively, an employee may be able to claim discrimination, so for example, victimisation or harassment. The new bill seeks to create a separate type of claim and a legal definition of bullying in the workplace. As such, employees would have a specific legal remedy for bullying. It also seeks to provide for a respect at work code to set minimum standards for positive and respectful work environments, and to confer investigatory and enforcement powers on the Equality and Human Rights Commission with regard to bullying. It's an interesting space to watch, as such a change to the law would likely give rise to quite an increase in employment tribunal claims. And regardless of whether the two bills I've mentioned become law, we'd always recommend that employers keep their employment policies up to date and ensure that there's appropriate training for both employees and managers. And that's to reduce the risk of employees bringing claims and to mitigate the risk of any claims being successful. These training sessions could be sessions that are delivered internally by individuals with the appropriate knowledge, or by an external provider, whether that's a specialist training provider or a law firm, for example. And now moving on to my final topic of whistleblowing. So we wanted to cover this briefly in the webinar. The first thing to note is that the government has launched a review of whistleblowing laws, and that was launched back in March this year. The Department for Business and Trade said that that the review would provide an up-to-date evidence base to inform government about policy choices to develop and improve the whistleblowing framework. It was looking at how the whistleblowing framework operates, including the Public Interest Disclosure Act 1998, which some of you may have heard of, and later legislative and non-legislative interventions. The research was due to be concluded this autumn, so we'll sort of need to wait and see if any legislative changes or otherwise come about because of the review. And finally, it's worth noting that ACAS published comprehensive advice on whistleblowing in June this year. It explains the law on whistleblowing at work very clearly, and notably how employers should respond to a protected disclosure. It flags the benefits of employers putting in place a whistleblowing policy and refers to the need to train managers on whistleblowing procedures and how to respond to disclosures. So it's certainly a useful reference point for employers. So that takes me to the end of my updates. I'll now hand over to Elliott for an update on visa fee increases. Thank you.
Thank you very much, Emma. So today I'm going to be discussing the immigration and nationality fee increases that are coming into effect this autumn and touching on the challenges that businesses will face when they, when they budget for recruitment and staff retention. So moving on to look at the fees specifically, there are going to be fee increases across the board, with the uplift ranging from 15% for visa fees to almost 50% for the immigration health surcharge. And priority services will be increased by 20% and standardised for both in-country and out-of-country applicants, which marks a change from the current position where the in-country fee is significantly higher than the out-of-country priority fee. This all comes despite industry concerns around the difficulty of workforce retention and recruitment post-Brexit, and on a very basic level reflects the government's need to fill the financial deficit. And indeed, a Home Office spokesperson confirmed this, saying that it's right and fair to increase visa application fees so we can fund vital public services and allow wider funding to contribute to public sector pay. So to put this into context, let's have a look at a couple of case studies and the typical kinds of scenarios that we see day to day, and look at how those new costs will impact on sponsors. So looking first at a typical scenario of a standard single out-of-country new hire sponsored by a large company for a 3-year visa where the 10 working day priority service is used, you're looking at a cost increase from around the 6,000 mark to around 7,500. And if you factor in another typical scenario, so a dependent partner with 2 children who are applying at the same time, you'd now be looking at more than 20,500 in visa fees alone. And that's minus your other ancillary costs like legal fees, English language test fees, translation costs, and all of the other potential expenditure that you as a sponsor and them as an applicant may need to incur to get an application over the line. Looking at the second case study, and now for a 5-year visa, the fees then increase substantially. So if you factor in using the 24-hour super priority service, you'd then see a jump from £10,510 to £12,834 for a single applicant. And if you then use the same family for example, as before, the overall cost would be a whopping £36,000. So a massive increase on the current position, and something that could potentially be prohibitively expensive, both for the sponsors and also for employers. So what can you as a business do to mitigate against those increases? Well, the reality is that if you have staff or skill shortages to fill, you will have to absorb the cost, but there are a few things that you can do to soften that blow. So, excuse me, recruitment plans and budgets should be scrutinized and adjusted based on projections using those new figures. Arm yourself with that information when you're looking ahead to the next 12 months and looking at how teams should be expanded or considering bringing in people for specific projects. There isn't now a great deal of time to accelerate future applications to get in before the fee increases, as some of these have already come into effect on the 4th of October, but it does still remain an option for the time being. And I think with that in mind, it's also important to give perhaps a bit more consideration to visa durations and consider whether it would be beneficial to maximize the visa duration. So you could apply, for example, for a 5-year term initially to avoid paying higher rates at the renewal stage, The question really then being whether it's better to absorb the 5-year visa cost now rather than paying a new raft of visa fees and priority fees after 2 or 3 years. And I think, you know, it really is food for thought for every industry and something that sponsors should be turning their mind to. And certainly we've had those kinds of conversations with a lot of clients since the fee increases were announced. Turning briefly to another area where the Home Office has upped the ante financially recently, and you know, the increases really aren't limited to just sponsor license holders, and it does reflect a general sort of financial position across the immigration sphere. So the Home Office have recently substantially increased its illegal working fines, and from January 2024, they will treble the civil penalty charge to £60,000 per individual employed without the right to work. And that's where the employer has unknowingly employed someone without the right to work. So say if you've undertaken a right to work check, but the document you looked at may have been fraudulent, you may have looked at a forged passport, for example, or an employee has used deception, and to the best of your knowledge, they had done everything above board. The ramifications, though, go beyond financial penalties, and the Home Office names and shames companies on their website. You'll see a number of household names have been publicly listed over the last decade where they have been found to be employing people without the valid right to work. If an employer knows or has a reasonable cause to believe that an employee doesn't have the right to work in the UK, they are in fact committing a criminal offence, and for that the maximum penalties are 5 years imprisonment and an unlimited fine. So the ramifications of getting it wrong and the ramifications of being involved and being complicit in illegal working are severe. Beyond the right to work aspect of immigration compliance, the Home Office can audit any business, and they do have a particular focus on sponsor license holders. So they will look very closely at personnel files and at right to work checks when they carry out an immigration audit, which will happen or should happen at some point during the 4-year lifespan of a sponsorship license. And those inspections can be triggered by a license renewal or by other activity on the license. So even things like changing or key personnel or adding a new office premises, for example, can trigger a Home Office audit. It's particularly important to consider that now, as post-COVID lockdowns, the Home Office have resumed in-person license audits, and we are aware from a number of clients anecdotally that that has really picked up on the immigration compliance side. And those audits can be carried out without prior notice. They can turn up and carry out a spot check. And actually, we had a client a few years ago who had the Home Office knock on their door at 5 p.m. on a Friday afternoon, simply because they had been in the area and had this particular client on their list of companies to inspect in future, and thought they would drop by and say hello. They can also give prior notice, so they could write to you and give you maybe 10 working days or 2 weeks notice and a list of things that they would like to see at the audit, which is a slightly more civilized way of going about it. Significant compliance breaches, and that would include record-keeping deficiencies, can lead to the suspension or revocation of a sponsorship license, and the ramifications of that can affect your entire sponsored workforce, who, in the worst-case scenario, could have their visas automatically curtailed, and then the sponsor, in tandem with that, could have fines issued to them, which obviously, in combination, could have some severe logistical, financial, and reputational ramifications for the sponsor. Really, the takeaway is that it's vital for immigration compliance in all of its forms to be taken seriously, and you really should be giving it the due consideration that it demands. So that's a very quick whistle-stop tour of the immigration fee increases and some of the compliance issues that we see on a day-to-day basis. And I will now hand over to Charlotte to discuss the flexible working regime. Thank you.
Thank you, Elliott. Good morning, everyone. So I'm going to take a look at the upcoming changes to the flexible working regime. So the statutory right for an employee to request flexible working has been in force since June 2014, and the changes to the statutory regime have been in discussion for several years now. And as we know, the flexible working movement gained significant momentum as a result of the COVID-19 pandemic, and the reforms are really now coming to fruition. So the Employment Relations Flexible Working Act 2023 has successfully passed through Parliament and is expected to come into force in summer 2024. There isn't a set date yet, but the government have said it will be next summer. And the Act amends the existing statutory flexible working regime set out in the Employment Rights Act making procedural changes to how employees and employers make and review flexible working requests. So the table that you can see on the slide in front of you summarises the current position, and the key changes that will be brought about by the Act next summer. So currently, an employee must have 26 weeks continuous service to make a flexible working request. And the proposed introduction of a day one right to flexible working is not introduced by the Act itself, but the government has reiterated its intention to introduce the change by way of secondary legislation at the same time as the Act comes into force. Employees will now be able to make 2 flexible working requests in a 12-month period, rather than just 1 under the current regime. But it's worth noting that a request may not be made while another application to the same employer is still being considered. The current decision period is 3 months, but going forward, employers will have to make a decision on a flexible working request within just 2 months, unless an extension is agreed between the parties. Employers will also have to consult with employees before they refuse a flexible working request going forward. And finally, when making a flexible working request, employees will no longer have to explain what effect they think the requested change would have on their employer and how that effect might be dealt with. And in light of this, I just thought it would be interesting now to put a poll question to you all and to ask whether your business would retain the requirement for employees to explain what effect their requested change would have and how that effect might be dealt with. So just a yes, a no, or perhaps you've understandably maybe not given this too much thought yet, so you might still be undecided, but I'll just give you a few seconds to put down your answers. Okay, that's quite interesting. So, I mean, yes, understandably, a lot of you are still undecided, perhaps haven't given this too much thought yet, but more of you would look to retain this requirement than wouldn't. And I think, the fact that the Act is going to remove the requirement doesn't mean that the issue can't still be considered and discussed as part of the consultation process. And you can, of course, still retain that requirement in any existing flexible working policy that you have. And I think it's probably advisable to do so, because doing this will help speed up the consideration of a request when it's made. So having looked at the upcoming changes, I think, overall they are quite limited. Whether to accept or decline a request remains in the hands of the employer. It is still a right to request, not to have a flexible working arrangement, and the 8 grounds on which a request may be refused are going to remain unchanged. So moving on to have a look at the ACAS Code of Practice. So the statutory provisions that I've just talked about are supported by the ACAS Code of Practice on handling flexible working requests. And the code sets out minimum standards of fairness that employers should follow in dealing with requests. It's not legally binding, but it is taken into account by employment tribunals when considering relevant cases. Now, the consultation on the new draft code closed last month, and the code provides guidance and a number of recommendations for best practice. For example, the draft code recommends that employers offer a meeting when any flexible working request is made, so both when a request is to be rejected or accepted. This is to ensure that all of the relevant information is understood, and it's part of I think a wider focus on encouraging employers not to just reject a flexible working request by default, and instead to engage in an open and meaningful dialogue. The draft code also proposes to extend the categories of individuals who may accompany employees to meetings to discuss a request, so that it will mirror the position for disciplinary and grievance meetings. So going forward, an employer should allow an employee that requests a companion to be accompanied by either a fellow worker, a trade union representative, or an official employed by a trade union. So now that I've covered most of the upcoming changes, it's worth having a think ahead, although it's going to be a few months still until the changes come into force, having a think about what steps you can take now. So I think first and foremost, you'll have to think about revising your existing flexible working policy to reflect the legal reforms that I've just discussed. And as mentioned, although employees are no longer required to explain the potential effects of their requests, for example, you could still consider encouraging this and retaining that requirement in your flexible working policies. You should also think about what your consultation process will look like now that that's going to be a statutory requirement. Many of you probably do already have a policy whereby you would meet with your employees to discuss a request. But as the ACAS code is suggesting, this should be really a face-to-face meeting. And perhaps also consider whether you would specify what flexible working options would be suitable for a job role in advertisements and identify candidates' preferences in job interviews. Although this will not prevent an employee from asking something different on day one of their employment, the hope is that discussing this up front at the outset of an employment relationship will allow a suitable pattern to be identified from the outset, rather than having to deal with a request in the first few months of employment. So in conclusion, I think it seems quite clear that the pandemic has marked the end of the 5-day office week for many, but organisations are still trying to determine appropriate levels of office attendance, and some industries, such as professional services, are pushing for greater mandatory in-office time. And submitting a flexible working request will be one means for employees to push back on these requirements. However, when responding to a request, it's clear that the balance of power remains with the employer, as statutory grounds for refusing a flexible working request are still wide. That said, employers need to bear in mind that flexible working is now widely valued, and many employees prioritise this over pay. So there's going to be a need to factor in retention and consistency across the workforce when responding to requests. That's all from me this morning. I'm now going to hand over to my colleague Sarah, who's going to be talking about the employment law implications of AI.
Good morning, everyone. Before I start, I'd just like to remind you that if you do want to raise questions, please do use the Q&A function at the bottom of the screen to raise questions, and we'll deal with as many as we can at the end. So I just want to talk about the employment law implications of AI, and to start with, I would like to talk about what is AI. So AI is an umbrella term for a range of technologies and approaches that attempt to mimic human thought to solve complex tasks. Things that humans have traditionally done by thinking and reasoning are increasingly being done by or with the help of AI. Now, AI can process large amounts of data and much, much faster than human beings. And chances are you've already been exposed to it either in work or outside of work. For example, we've all probably used a chatbot instead of speaking to a customer service clerk. Next, I just want to talk about the types of AI. There's lots and lots of jargon and various subcategories of it, but I just want to give you a flavour for some of the more obvious ones that you may have come across, or ones that are kind of the bigger news. You may have heard reference to what's called generative AI. It refers to a type of AI which can be used to create content. You'll also probably hear reference, if you're looking into or in the news, about large language models, or something called LLMs. And they generate human-like text. And that includes the chatbots that I've just mentioned, but also ChatGPT, which I'll come on to later, and Google's Bard. They're good at working out which words follow another. The next thing that you probably come across in the context of employment is algorithmic management. And that refers to the use of AI by employers to manage workers. The term was first used by academics to describe the use of software used by gig economy firms like Uber to assign work, monitor, evaluate, and control its workers. It relies heavily on data collection about the workforce, and it's therefore closely related to workforce surveillance. In the context of AI, you will also hear reference to what's called prompts. Prompts, for AI purposes, are the inputs or queries that a user provides to the AI application to receive an output. And prompts can be used to train AI. Another thing, more negative thing that you will hear in the context of AI is something that's called hallucinations. AI may produce outputs which may initially appear to be believable, but which are highly inaccurate or fabricated, and that's what's known as a hallucination. AI, as you have probably heard in the news, is predicted to have a considerable impact on the job market and bring about job displacement for those roles that AI can do well or better. We will see change in the immediate future within the next few years, but experts predict that the biggest impact from AI will be seen once 5G coverage is widespread across the UK. And at the moment, as you may know, it's quite patchy. With the emergence of AI technologies, the landscape and skills that workers will need to have will shift dramatically. Employers and workers are going to have to adapt to what some experts are predicting to be the next industrial revolution. And it's expected to transform all aspects of our lives, not just the world of work. For example, education and healthcare are expected to be fundamentally transformed by it. I just want to come on next, saying on the same slide, to two key aspects of AI, data and algorithms. Data may include text, audio, images, video. It's quite broad. Algorithms, which you'll have heard lots of, are essentially sets of codes with instructions to perform specific tasks. And algorithms, by their nature, learn from the data that they receive. They recognize patterns, reach conclusions, make judgments, predictions, and they automate repetitive functions. However, we need to be really careful about what information those algorithms are fed. If, for example, the data that an algorithm is fed contains certain biases, the algorithm can and will perpetuate or even amplify those biases. And this can lead to AI tools making decisions that are discriminatory or unfair. So it's really important that AI developers and users like yourselves use diverse data sets when using AI and continually monitor your AI systems for signs of bias. Just going to come on next to something I want to just talk briefly about ChatGPT. It's currently one of the best known examples of AI. It launched in February 2023, and in 3 months it had 100 million users. The pace at which it was adopted has been utterly staggering. For example, if you look at TikTok, it took 9 months for TikTok to reach the same number of users, and it took Instagram 2 years. ChatGPT, bit of a tongue twister for me, it's really good at creating text that sounds like it's written by a person, based on the prompts that I referred to earlier. Students are using it, workers are using it. But are you happy for your workers to use it? It's time for a poll question. A question will pop up on your screen shortly. I'd be grateful if you could answer it. Has your business given permission to its workers to use ChatGPT? If you could answer yes, we've also introduced a policy. No, our workers are not allowed to use it, and we have updated our disciplinary policy to make it clear that they will be disciplined if found to be using it, or we have yet to make it clear to our staff whether or not the business is happy for them to use ChatGPT. Just give you a couple more seconds while we get the results in. As I thought, although it's all over the news and lots of people are using it, and you've probably got employees in your business that are already using it quite extensively, most of you have yet to make it clear to whether staff can use it or not. I'll come on to some of the issues and why you might need to kind of give that a little bit more consideration. As an output, what comes out of GPT is different every single time. So it's going to be really difficult for you as an employer to spot when your employees or workers are using it. It has the knowledge of the entire world at its fingertips. So as well as learning from all the good stuff on the net, it also gets information from all the bad stuff, including conspiracy sites and extreme political platforms. It has absolutely no judgment. It cannot tell the difference between what's appropriate and what is not. So it needs a human eye to check it. It shouldn't be relied upon without checks and measures in place. It can make things up. It cannot be relied upon to be accurate. It can create what I referred to earlier as those hallucinations. You will need to decide, if you haven't already, whether you're happy for your workers to use it when they're doing their work. And unfortunately, I've read numerous articles in the papers in which employees are saying that they're using it quite extensively, and some of them are using it so much to do their work that it's actually freed them up to take on other employment, and they haven't told their employers. I just want to talk further about ChatGPT. When using it, there are also serious concerns for your business about privacy, confidentiality, and security. So to use it, for example, an employee could put your marketing list into it, and that would be disseminated and would be used by the system. You can't get it back, you can't control it. It could use your price list or put that in there, or other company confidential information. So a question a lot of employers have found themselves asking is whether they're going to allow it to be used a lot or not. Do the benefits outweigh the risks, and can those risks be managed? And some employers have thought, well, okay, I do want people to use it. It can be beneficial, but I do want to put some parameters in place. So they put in place ChatGPT specific policies, which set out what their employees can and cannot do, and when it can be used and when it can't. Doing so is fine, I think, and I would recommend that you do that. But the speed with which the technology is changing is so immense. And that although everybody is talking about chat GPT now, it's highly likely that some other successful form of generative AI will come along and replace it quickly and make chat GPT obsolete or old news. It may be better, therefore, I think, for employers to adopt a generic policy on the use of generative AI by employees, rather than a chat GPT specific policy, to ensure that you're covered for emerging technologies that your workers may be tempted to use. In any such policy, it's advisable to set out, among other things, what AI can be used for work purposes, what sorts, how it can be used for what sorts of business activities, and what your business expects. If you're interested in putting a policy in place or would like to chat through some of the issues giving rise to the aspects I'm talking about today, get in touch after the webinar. And some of you may be wondering what all the fuss is about and you haven't had a go on ChatGPT yourself. You can set up a free account at the address on the slide. And if you want to, you could just have a go and see what it can do and see how powerful it is and have a play around with it. Just coming on to when it may be relevant in the context of employment. I've inserted some examples of when AI may be relevant in the context of employment onto the slides. And as you can see from the examples, it could potentially impact the entire life cycle of the employment relationship, from recruitment all the way through to termination of the employment. And as a business, you're going to need to decide how and when you deploy it, and on when you're going to still rely on humans to take decisions. I'll just move on to the employment law obligations in the next slide. There are currently no direct UK laws governing the use of AI in the workplace. However, there is some current UK legislation that could potentially restrict its use. But please bear in mind that existing legislation was not designed with AI in mind. At the time it was passed, AI didn't exist or was not in the minds of those who drafted the legislation. So arguably, whatever we've got in place isn't fit for purpose. So I imagine that when AI issues pop up in the workplace, employees may start deploying common law arguments about the employer's use of it was a breach of mutual trust and confidence. And I think there could also be Equality Act issues in that employers say that the employer's use of it is, or decisions that they've made on the back of it can be said to be discriminatory. As I mentioned earlier, AI can exhibit bias because of the way it's trained, unless care is taken to minimize any such bias. I wouldn't advise you at all to simply just adopt it and think that's the end of the matter. You're going to have to keep an eye on what information it is fed, on what its outputs are, to manage the risk that using it poses. There have already been occasions when employers have had to pull back from using it. A famous example is Amazon started using it in its recruitment processes, and it had to stop when it realized that AI was recruiting a disproportionate number of men and discounting far more applications from women. So the output from AI can be incredibly impressive. However, it can also have surprising results and can give rise to issues and things that you may never have wanted as an organization. As AI involves the harvesting of immense amounts of data, which would include employee data, there are also data protection and GDPR implications. Now, Article 22 of the UK GDPR provides data subjects with the right not to be subject to a decision based solely on automated processing. While potentially a significant restriction on the use of AI decision-making by employers, as far as I'm aware, the Information Commission has not yet issued any penalties to enforce this provision. But what I imagine it will do, that will happen in the future. And when AI really takes off, that may be relied upon more. There is currently the Data Protection and Digital Information Bill currently going through Parliament that would replace the current general prohibition on automated decision-making with certain specific safeguards which employers have to bear in mind. So keep an eye out for that. And I also imagine that some employees may also try and deploy human rights arguments, for example, a breach of Article 6, which guarantees their right to privacy. Coming on next, I want to just think about the potential legal issues that could arise from you using AI in your business. we've got to think that just because a machine is making a decision doesn't mean to say there's no risk and no bias. There is still potential for discrimination in recruitment decisions and other employee management decisions, such as disciplinary issues or redundancy or performance management related issues. There's also a risk of the kind of claims or issues arising that I've put out on the slide, whistleblowing problems, data protection, and contractual issues as well. I just want to end now with just talking about the future of AI. The UK government's plan is to take, at the moment, a non-statutory approach, relying on existing regulators like the Information Commission's Office to oversee the use of AI in their areas, while following what it's kind of saying is 5 broad principles: safety, transparency, fairness, accountability, and contestability. But already those regulators are asking the UK government for a lot more money and resource to do what the government is proposing, because they're concerned they're not going to have the resources. The EU, in comparison, is being far more proactive, and it's in the process of introducing an AI-specific act, which looks like it'll be a lot more interventionist than what the UK government is proposing. Something that I read recently, which is really quite interesting, is something that the TUC recently published. They published a manifesto which sets out what the TUC considered to be the key issue for employers and employees. It reads like a wish list of things that the TUC would like to happen, and obviously not all of it will come to pass. But I thought that it made for some pretty interesting reading, as it predicts some of the issues that employers are going to face and the arguments that employees will make in the future. And I would highly recommend that you take a look at it. For example, the TUC plan to lobby for a legal right for employees to have high-risk decisions relating to their employment to be made by human beings, and for a legal right to in-person engagement at work with human beings. Now, high-risk decisions, by that they mean whether someone is promoted, recruited, made redundant, disciplined, etc. Now, it might sound like science fiction, but if AI takes off as it's predicted, we will find more and more decisions about our lives are taken by machines and not by human beings. And the TUC are predicting that very soon workers will work alongside machines instead of humans, and some workers may not have human line managers. The TUC believes that as human beings, we should have a legal right to engagement with other human beings while we're at work. Which is, for my purposes, a rather sobering vision of what the future world of work might look like. I hope that what I've discussed has whetted your appetite about AI. I think it's a really, truly fascinating issue for employers and its possible impact on the world of work. If you would like to discuss further, do let us know. And now I'm going to hand back to Devan, so hopefully some time for some questions.
Thank you, Sarah. So a really interesting set of presentations today on a variety of topics. And we're just going to go through a few questions. The first one is for Anna. Anna, is it okay to have alcoholic drinks at team meetings? So we've talked about social events. What about team meetings?
Well, look, there's no absolute ban on it. But it's one of those things where it's fine until it's not fine. And I suppose as an employment lawyer, I see those instances where it's gone wrong. And I think my advice would be, if there's any work focus to the meeting, any serious element to the meeting, then alcohol should not be included. But it might be at the end of the meeting, if there's a social element, you can include it. That would be my advice in a nutshell. And I think the bigger problem that I see in practice is slightly off point, but worth mentioning, is when people, particularly senior people, gather in pubs and bars for a drink after the working day. Some people don't go, maybe because of childcare responsibilities, whatever. And it's at those informal meetings that decisions happen, you know, whether it's because people form cliques, and it might be that certain men, for example, are put up for promotion, and you might see in a grievance by a female senior exec that she felt excluded, and she felt as though important decisions were made at the pub and she didn't have a fair opportunity to apply for the same promotion. So it's those types of arguments that I see in practice. But in answer to the specific question, I would say just don't have booze at any meeting where there's a serious work element to be discussed. Keep it social.
Yeah, exactly. It's making sure it's all included,
Yeah.
and those who don't feel comfortable with it are not going to be excluded from important work-related things. A social event, takes on different
I mean,
context.
it's a bit like the golf club argument, I think, where, and I've seen this as well when acting for female senior execs, where she might claim that the decisions are made at the weekend on the golf course. It's that kind of analogy, I think. Yeah.
Absolutely. We've had a question in for Elliott relating to visa fees, and obviously Elliott talked about the large rise in visa fees. And Elliott, the question is, what visa fees can you make the employee pay, given this rise in costs? How much can you share that burden?
Yeah, and it is a question we get asked all the time, even before the fee increases, because obviously the visa process itself has always been costly, with numerous different kind of itemized different fees to pay at different parts of the process. I mean, fundamentally, the certificate of sponsorship and the immigration skills charge, which are paid as a lump sum when you assign the certificate, they have to be covered by the sponsor. You can't put that cost back on the employee either at the time of the application or anywhere down the line. And that is confirmed by the Home Office, and they would take that pretty seriously if a sponsor has done that. The visa fee itself, the health surcharge, and the kind of ancillary costs, so priority fees, English test costs, that sort of thing, they can all be paid by the applicant. So it is reasonable to ask the applicant either to cover the costs themselves or to split the costs. I mean, our client base all do things slightly differently. Some of them may reimburse costs to an applicant after the individual has paid them at the submission stage. Others will submit the forms on their behalf and pay all of those costs for the employee at the time of making the application. One thing that you can do, and this is something that we've advised on both in an employment and immigration context, are introducing clawback provisions in employment contracts that would require the repayment of visa fees if someone was to leave the business within a certain amount of time. So you could require say a 50% repayment if someone leaves within 12 months. And that way, when it comes to those visa fees, you're not going to be necessarily out of pocket if someone leaves, and you can, effectively be refunded some of those fees from the individual, where you as a sponsor have paid for them up front. What I would say in that regard is it's important to make the distinction between the costs that can be repaid to you and the ones that can't. And certainly that distinction of the overall cost that you are asking to be repaid, not including the COS and the skills charge, is an important point. The Home Office may well look at employment contracts at an audit if they saw there was a provision that required the repayment of all of the visa fees, including the COS and the skills charge. That would almost certainly be taken as a pretty serious compliance breach.
Yeah, it's interesting actually, because it's so rare that we see these clawback provisions. I would have thought employers would have put them in more often, but you are seeing employers think about it, because you don't want an employee to come in, leave after 6 months, and you've given all this. Of course, some of the fees as well are refunded if an employee leaves early. I'm conscious of time, so what we're going to do, we can stay on for a few minutes longer, but for those of you who need to drop off, of course, feel free to. Those of you who can stay on, you're welcome to. Just a reminder that if you dialed into the webinar, please email the events team at events@wfw.com, and that way we know you attended, so you can get the feedback form and the slides afterwards. And you'll get an email tomorrow with a short feedback survey. We really do value your feedback, so we can make sure that we're improving these webinars and making sure they're relevant, thinking about topics that may be interesting to you. So please do complete that for those of you who need to drop off. But those who need to stay, please do stay on for another couple of questions. Emma, there's a question for you here. So what steps should an employer take where an employee reports that they're being bullied?
Thanks, Devan. So you'd really want to look at it in the way that you would if an employee raised any kind of other conduct issue. So first of all, seeing if it can be resolved in an informal way. Of course, it may not be possible or appropriate to try and resolve a bullying complaint informally, and then the next step would be to deal with it formally. You should direct the employee to the company's grievance policy, and sometimes what employers will do is have an anti-bullying policy and then cross-refer to the grievance policy, which is quite a neat way to do it, rather than having sort of a policy within the anti-bullying policy relating to grievances. And while I'm on that point, actually, it is worth sort of saying that we do often recommend that employers have these standalone anti-bullying policies, because, as I say, they can easily cross-refer to a grievance policy, and then it's a good way of an employer setting standards of behaviour. And also another benefit is that if a bullying claim has a discrimination angle, then it may actually help an employer make out a reasonable steps defence to a discrimination claim where the allegations relate to discriminatory conduct.
I mean, if I could just add to that, sorry to butt in, I think with any of these policies, the gold standard is to accompany the policy with training, whether that's multiple choice training or in-person training. So that will put you as the employer in the best possible position, I think, to defend yourself against those types of complaints. And what I've noticed particularly is bullying on social media. This seems to be a growth area, right? So WhatsApp exchanges between certain colleagues against another colleague. And so it's tying together all those different strands in terms of your social media policy, your bullying, your grievance, etc.
Yeah, and what we're finding is tribunals, it's no longer a defence for employers to simply say, we had a policy in place.
Yeah.
It's that point, making employees aware of that policy, what it involves, because just having it in your handbook and, no one looks at it is not going to be enough.
It's like the sexual harassment point I made earlier. I think everybody has a different conception of what harassment is.
Exactly.
So it's about educating.
Absolutely. Charlotte, there's a question for you here. So can employers agree to a trial period to test flexible working?
Well, the current legislation doesn't actually provide for regulate trial periods, and it's not going to be covered by the reforms either. But there's nothing in practice to prevent an employer from agreeing a trial period. I think it can probably be to both parties' advantage, really, particularly if you're unsure whether the request being made is going to be sustainable for the business. It's a good opportunity to trial it out for a short period of time to see how things work out. I suppose one point to flag is that if you do agree to a trial period, you're probably going to need to agree to extend the decision period with the employee that's made the request, because if we're looking next summer at the decision period being reduced to 2 months, you need to allow the time for the trial period and potentially an appeal if after the trial you decide that actually the arrangement isn't working. So you might need to agree with the employee that you're going to extend that period for a longer stretch of time. But yes, absolutely, trial periods are, I think, probably something to be considered in most circumstances, and there's nothing to stop you from doing that.
Yeah, I think trial period is a really good tool for testing it out, seeing how it's worked, iron out some issues before you give a concrete yes to it. You might need to make tweaks or modifications to the arrangements to make it work, and it's easier to do if you've got that trial period to have that conversation.
But I tell you what you need to do, you need to diarise the end of the trial period and also have a meeting part way through the trial period, because what happens is people forget. And then the employee thinks, I'm not going to say anything, I'll just continue as is. And then if the employer subsequently tries to revert to the original working arrangement, the employee might say, well, hang on, I've got this reasonable expectation now that it's been agreed over the passage of time. So it's about making sure it's not missed. Yeah,
you see that with probation periods as well. People forget that time passes and stuff. So it's really important to have this sort of diarising and making sure you are checking up if you're going to implement anything like that. We are quite a bit over. We're going to one last question before we wrap up quickly. It's for Sarah. So do you think that AI will have a positive effect on the world of work, Sarah? Your quick answer to that.
I think it has the potential to transform business. It's great for business. I think it's going to transform all our lives as well. I think for workers, we need to get on board with it or risk being left behind. I think there will be some job losses, jobs that AI can do well or as better will be done by AI. But the plus is that arguably workers will be freed up to do more interesting work, strategic work, or complex works. I have concerns about businesses using it without checks and measures in place. But we're living through exciting times. AI is coming, it's coming fast, there's no stopping it, but we just need to use it carefully and monitor its outputs, as it's not without risk from an employment perspective.
Yeah, exactly. It's like when anything new comes along, making sure you've got rules, policies, procedures in place to deal with it. You know, principles, you can't get into the detail, but principles as to how and make your workforce aware. So thank you to all the panel today for your presentations and responding to those questions. And a big thank you to everyone who joined us today for this webinar. As I said, you will get your feedback forms tomorrow, so please do let us know how we did, and you'll get a copy of the slides as well, and the recording will be available once it's ready as well. So thank you very much for joining us today. Thank you, everyone. Thank you.
Bye.
Bye.